Welcome to our family law update, and thank you to Suzanne Kelly from Guildford Chambers presenting this for us. Just before we get started, I wanted to make you aware of some forthcoming training and events the Society is holding. Tomorrow we've got a guide for conveyancers and litigators actually on navigating properties let on an Airbnb basis in the UK. That's a webinar. On Friday we have our Sailing for a Cure legal charity event in aid of Cancer Research UK. And next week, we're holding an online course, 5 Key Principles to Highly Profitable Delegation for Law Firm Owners and Partners. That's with Dan Warburton, and should be a really excellent session. We've got other things coming up as well, some supporting Surrey sessions on financial wellbeing, and you can view the full programme at our website, surreylawsociety.org.uk. For this session, just a few brief housekeeping notes. So we have a 5-minute break at around 1 p.m. In terms of Q&A, as we're holding it as a meeting, you can unmute yourself and turn your cameras on if you'd like to, but we'd ask you do that when invited by Suzanne. She will intermittently ask whether anyone has any questions, so you can either unmute or you can put your question in the Q&A box, type it in there, or you can raise your hand. The course is being recorded, and lastly, we will be sending out a feedback form at the end of the session alongside the recording, so ever so grateful if you could complete that. Right, with no further ado, I will hand over to Suzanne. Thanks, Suzanne.
Thank you very much. Good afternoon and welcome. As previously said, my name is Suzanne Kelly, and I am being assisted today by Kane Deach, also from Guildford Chambers, and we're delighted to present this family law update. I'm going to start by talking to you about experts in family law, not in respect of the need for experts. That is settled case law, and we are all aware that the test for that is that it needs to be necessary and proportionate. What I'm going to be speaking about today is what constitutes an expert. And I'm just going to wait for Kane, there we go, to put up the first slide. And I'm going to be looking at a case called Re C. It's a case that arose in respect of parental alienation. But what arose out of that is the issue of what constitutes an expert. And this was a case that centred around a family where there had been serious and significant findings made against a mother in respect of parental alienation. She made an application to appeal a judgment, and that permission was granted for her to appeal by Justice Peel on the 15th of July, not because the proposed appeal had a real prospect of success, but for some other compelling reason, namely that it was in the public interest for the court to consider the instruction of unregulated psychologists as experts in the family court, and in particular in respect of the expert referred to as Miss A, in this case, her instruction and her role in this case. The judgment therefore focuses on the issue of instructions in proceedings where there's an allegation of parental alienation, rather than the parental alienation itself, but it's very useful in respect of what constitutes an expert. So in this case, the father had made an assessment for a child psychologist, a Part 25 application, or a child and adult psychiatrist to be instructed. Both the mother and the children's guardian agreed that instruction was necessary. The court, having heard submissions, concluded that the instruction was necessary. The order in that matter records, so far as the instruction was, that the discipline of the expert shall either be a child and adolescent psychiatrist or a psychologist. Permission was given to the expert to see both children. So it's a fairly vague direction in terms of who was going to be instructed. And the identity of the expert, referred to as Miss A, was only confirmed and agreed after the hearing, and therefore paragraph 28 of that order which mistakenly refers to Miss A as Dr. A, was therefore added after to reflect that development. Now, the recommendation by what was made by the children's guardian for Miss A to be instructed, and her CV was a little bit confusing to read, but suggested a fairly extensive knowledge of parental alienation. What arose out of this judgment was that it appeared that the court had lacked the necessary rigour in considering what expert should be instructed. And in particular, the order did not specify the required professional discipline of the expert as between psychology or psychiatry. It does not seem either that Miss A's CV was ever submitted to the court, and the court order, presumably agreed between the parties' legal advisor, erroneously describes Mrs. A as Dr. A. In any event, Mrs. A undertook her work in the summer of 2020. Her report was filed on the 12th of October 2020 and was plainly influential. She concluded that the children had been significantly alienated from the father by the mother, that one child was significantly and seriously alienated, and the younger two were on the similar trajectory. And therefore, at a hearing on the 16th of October, only 4 days after receiving that report, Her Honour Judge Davis ordered removal of the children from the mother's care with a transfer to father, and no contact to mother pending further fuller hearing on the 29th and 30th of October, following which some limited contact was directed pending a fact-finding hearing, which, due to various unforeseen and unavoidable delays, including illness of the guardian and court availability, didn't take place until June 2021. And the mother applied for permission to appeal the fact-finding part of that judgment. Permission to appeal was refused initially by Justice Peel on the 1st of September on the basis that the application was totally without merit. And it's of note that on that appeal, one of the grounds was that the judge was wrong in relying upon the report of Mrs. A, who holds herself out as a psychologist and gives diagnoses that she's not been qualified to do so. On the 3rd of February 2022, whilst in court on a further issue that arose in respect of those proceedings, the mother issued a fresh application to reopen the issues that had been determined in June 2021. And she made her application in these terms. The application is to reopen the finding of fact and welfare determination to review the safety of the findings made on parental alienation in light of the concerns about the significance attached to Miss A's opinion as set out in her assessment. On the 20th of April, the mother issued her an application under Part 25 for permission to instruct an expert in support of her application for the June 2021 findings to be reopened. The sole focus of the expert instruction was to advise on the professional and/or clinical qualifications of Miss A to undertake the assessment of the adults and/or the children in the manner sought by Miss A's instructions. And the expert to be instructed was Professor Wang, a clinical psychologist who is the chair of the Association of Clinical Psychologists. The judge considered the application on paper after receiving written submissions from all three parties. The judge also had seen an unsolicited email which Professor Wang had sent to the court in January 2022, in which he set out his view of the expertise of Miss A. The letter that's relied on is undated, but was sent to the court in January 2022, rather confusingly headed with the name of an individual who was not a child or parent in that case, and it reads in full as follows. I write to state that I have examined Miss A's CV and confirm that she has no recognised substantive postgraduate qualifications, is unregulated, should not be calling herself a psychologist, and should not be carrying out psychological assessments and making diagnoses. And whilst I acknowledge the appointment of expert witnesses at the court's discretion, in my opinion, she should not be acting as an expert in court. She does not possess any doctoral qualification, is not a medical practitioner, and therefore should not be referred to as Dr. A. An order of the 10th of May, the judge concluded it was not necessary to have an expert opinion from Professor Wang before determining the application to reopen her findings, and the Part 25 was dismissed. And accordingly, the mother made a further appeal, which, as referred to earlier, was allowed on the basis that there was some other compelling reason. So in terms of those recommendations by the court in respect of their clinical psychologist, what the court determined was that there was no criticism of the appointment of the clinical psychologist. It had been agreed by all parties, and no party had sought to have a different psychological report prior to her report being received. What this case did, the judge, when giving judgment, had a robust look at the President's memorandum of experts in the family court, the main body of which provided an explanation of the basic principles of instructions of experts. And the final paragraphs dealt with qualifications and regulations. And what it sets out there as that paragraph 25B 4.1, that an expert is required to comply with the standards set out in the annex. Their requirements had to have been active in the area of work, to have sufficient expertise of the issues, to have familiarity with the breadth of current practice or opinion, and if their professional practice is regulated by a UK statutory body, they're to be in possession of a current licence, up to date with CPD, and have received appropriate training on the role of an expert in the family court. Psychologists mainly regulated by the Healthcare and Professional Council. The Family Justice Council has issued guidance along with the British Psychological Society on providing expert reports. And where the expert is not subject to statutory registration, such as a child psychotherapist, paragraph 6 of the annex identifies alternative obligations to ensure compliance with appropriate professional standards. I'm just going to wait for the next slide to load. What the judge said in this case is that the family court, as we all know, adopts a rigorous approach to the admission of expert evidence, and it has to be based on an established body of knowledge. Otherwise, it will be inadmissible in court. What this judgment confirms at paragraph 87 is that, rather unfortunately, there is no definition of an expert in family proceedings, save for the circular procedural definition at Family Procedure Rules 2010, which says an expert means a person who provides expert evidence for use in proceedings. Certain statutory exceptions are set out in the Children and Families Act 2014. I'm not going to go through the paragraphs 89 and 90 as they are fairly self-explanatory, but what arose out of this case, and which I find quite interesting, is that there are only certain titles of psychologists which are or have what's called a protected title, so that only qualified people can use those titles. So those are a clinical psychologist, a chartered psychologist. The generic label psychologist is not protected and may be used by any individual, whether they're registered or not. So that means that any of us could go online, do a quick course and call ourselves a psychologist. What the court has said is that a report by an unregistered person calling them a psychologist should not be referred to as a psychologist report, but may be called a psychological report. And so in this case of Re C, where the court found that whilst the Miss A was not necessarily qualified as a psychologist, her CV did set out the extensive experience that she had in parental alienation, and the court was entitled to rely on parts of her evidence where it was clear that she did have the requisite experience. Let's move on to the next slide. Great, thank you. What the judge did say was that in concluding his judgment, that it's a matter for the psychological profession and ultimately Parliament whether a tighter regime should be imposed. At the moment, currently, as we stand, there are no outstanding papers to be decided by Parliament, and as far as I'm aware, there is nothing by the psychological profession that is seeking a tightening of those regulations. In summary, the President notes that there's need for rigour during the process of identifying and approving an expert for instruction in family proceedings, and indicates that this work should be done to assist parties in the court at the initial stage of choosing an expert by establishing a template into which the basic qualifications of any psychologist should be entered. And of course, our updating child arrangements orders from October of last year, and indeed earlier this year, set out in the standard directions references to the instruction of experts and what should be included within that. And I'm pleased to say that the cases that I have undertaken recently, the courts have been very robust in considering the CVs and the questions, going as far as wanting to approve post-hearing the letter of instructions. There's a very good link at the bottom of the last slide, which links to and gives guidance in use of experts in cases, particularly in respect of alienating behaviours. So what this case was also interesting for was that the Association of Chartered Psychologists were allowed to intervene in the appeal, although the judge in giving judgment said it was most unhelpful, and the intervention of the Association of Clinical Psychologists in the proceedings had to some extent muddied the waters, elongated the proceedings, and had not been helpful at all. Ultimately, the appeal was dismissed. The judge's findings were freestanding, and as previously said, the impugned experts' analysis only formed one part of the canvas of evidence that formed the basis of the decision. And of course, we're all aware that the court has to survey the broad canvas in determining any issue. The takeaway from the case, however, is the guidance offered by the President regarding the process of identifying an expert. And I'm going to hand over to my colleague Kane, who is going to take you through the issues with cognitive.
Thank you, Suzanne, and hi everyone. Hopefully you can hear me. If you just allow me a moment just to load up on my side. There we go. Yes, thank you, Suzanne. My name's Kane. I'm a barrister at Guildford Chambers, and I'm going to talk to you about, as you can see from the slides, the case of Re Y. I've included the citation at the top of the slide if you wish to take a note. And it is an interesting decision from the sphere of public children law. The judge who presided on the case was Mrs. Justice Leven, and she intended for this judgment to be a sort of pointer or some guidance regarding making applications specifically for cognitive assessments. And you can see from the slide that I've noted that it is a cautionary tale, and I think that's to put it lightly, because it is, if you have the time to read it, is quite a stern judgment given by Mrs. Justice Leven. The judgment itself is not very long. So as I said, I would encourage everyone who's practicing in the sphere of public child law to have a read of it when they have the opportunity. But just before I actually delve into the judge's reasoning in that case, she did make a few preliminary remarks at the beginning of her judgment, and they were mainly tellings off, basically. She bemoans the fact that the actual Part 25 application for a cognitive assessment had been withdrawn, as it turns out, only a few minutes before the hearing itself. That was convened, amongst other things, to consider the actual application. And she bemoaned this as a waste of court resources. And she also gave, again, a bit of a telling off regarding the filing of both position statements and skeleton arguments. In fact, there had been a stipulated deadline in the previous case management order for a position statement to be filed by a certain date. So perhaps goes without saying, but of course, you know, we're all to adhere to deadlines, and you open yourself up to the risk at a hearing of being firmly slapped on the wrist if you don't stick to that. But if I just turn to the next slide, give me a moment, I'll load it on my side. Yeah, so in terms of the case itself, factually, and the factual backdrop, it isn't remarkable. And of course, as with a lot of public child law cases, it is desperately sad what's happened in the background. But of course, for practitioners in the area, it's not at all unfamiliar. To summarise it shortly, essentially the local authority had obtained an interim care order, and the interim threshold was based on the fact that the mother had failed to engage in antenatal services after, shortly after the birth of her child, the subject child, in fact, in the proceedings. And there was also this separate issue of the mother's association with the father, who did have a litany of offences on his record. So those two reasons underpinned the interim threshold. And the mother herself, the local authority initially suggested interim separation, but that was changed quite late in the day to a foster placement for both the mother and the baby. So the interim care order was made, and the mother solicitors, they, as I said earlier, they lodged a Part 25 application for a cognitive assessment. And of course, they provided all the necessary details with that. But in the statement in support of the Part 25 application, and this was picked up by Mrs. Justice Leven in her decision, the reasoning behind the cognitive assessment being sought, it was asserted that, and I'm quoting from the judgment, it was said that the mother has indicated that she struggles with engaging within professional meetings and retaining information. So that was essentially the kind of base assertion behind a cognitive assessment being sought. But it later turned out that essentially when Mrs. Justice Leven picked up on this in the hearing, it was explained by the mother's representative at that hearing that essentially really the reason behind the cognitive assessment was because counsel at an earlier hearing in the proceedings had essentially fed back that they had concerns regarding the mother's presentation. So that was really the true reason behind the application being made. And as I said earlier, in this case, on the day that Mrs. Justice Leven dealt with the matter, the application for the cognitive assessment was withdrawn at the 11th hour. And the reason given by the mother's representative for that is really twofold. The first is that the mother's representative hadn't actually had an opportunity to meet the mother in person before that hearing. And then when they had that opportunity prior to the hearing to have discussions, they formed the view that a cognitive assessment wasn't necessary because they didn't have any communication issues and didn't observe anything else that needed further inquiry. But the second reason was that the mother was doing very well in the mother and baby placement. So it was really those two reasons that led the Part 25 application being withdrawn at the last minute. And when pressed by this by Mrs. Justice Leven in the hearing, the representative said essentially, and you'll see I've quoted this on the slide, is that it was essentially part of a belt and braces approach adopted by her representatives. Now, I'll talk about Mrs. Justice Leven's decision in a moment, but you can imagine that's probably not the best prelude to seeking that application to be endorsed. But as I've explained on the slide, I've set out what the interim threshold was in that case, and you'll note that there were no specific communication or cognitive functioning issues expressed in either the interim threshold or the SWET, the social worker's evidence. So that, again, that provides a bit of a prelude to what Mrs. Justice Leven decided eventually. If I just turn to the next slide. And I've got an excerpt from her decision here, and I'll read it out, the quote itself. She said at paragraph 22 of her decision, it will often be the case that parents may struggle to absorb information, to understand the proceedings, and to concentrate through meetings and hearings. However, the solution to this problem is not, in the majority of cases, to have cognitive assessments and appoint intermediaries. It is for all of the professionals involved, including lawyers and judges, to bear closely in mind the need to use simple language, avoid jargon, and where appropriate, check that a litigant has understood what is being said. And of course, as Suzanne has already set out earlier, the fundamental test under Part 25 is one of necessity. And the judge commenting on that said, test of necessity does not mean that report would be nice to have, or might help in determining what psychological supports the parent might need in the future. That's not necessary to resolve proceedings. So that's just a flavour of her judgment. But as I said earlier, I would encourage everyone to read the judgment in full, because there are other certainly stern sections of it. But turning to the next slide, I think if I can summarise the key takeaway from this case, and again, this perhaps goes without saying, but it's nonetheless a useful reminder, is that you really need to be on firm ground when you make an application for a cognitive assessment, and avoid speculative applications for such. Of course, the obvious risk, if you do make such an application without a firm basis, is that you'll be picked up on it in the hearing, as the mother's representative was in this case. But there is an interesting corollary in this case. It's not only regarding the mother's position, but it was also actually that of the guardian's stance taken in the hearing, which Mrs. Justice Leven took issue with. And again, I'll quote what she said at paragraph 17. It's in my view unfortunate the guardian and her solicitor stated that they were neutral. It's quite clear from the skeleton that the guardian did not consider the test for necessity in Part 25 to have been met, but still remain neutral on the application. Guardians and the children's solicitors play an important role in care proceedings in ensuring that the interests of the child are met by minimising delay and maximising the efficient use of resources, particularly by assisting the court to make cases smaller. That's a quote from the President's guidance. If it is clear to the guardian and the child solicitor that an application should be refused, then they should make that clear to the court. So again, another key takeaway from this case is that if you are representing the guardian in proceedings, and you do feel that, and I suppose this actually extends to really any application for expert assessment and not just cognitive assessments. So if you feel that those applications are meritless, and that is a view held by both not only the guardian but also, of course, the solicitor and perhaps even counsel, then you shouldn't sit on the fence about it. You should express that fairly clearly. So those are, I hope that was helpful in terms of cognitive assessments in the public law context, and those are, as I say, really the two key takeaways from that case. I'll pass you back to Suzanne now, who's going to talk in some detail about fact-finding hearings and schedules of allegations post re-HN.
Thank you, Kane. Just before we move on, are there any questions arising from what you've heard so far? Oh, wonderful. I shall move on now to where we are with fact findings and schedules of allegations post H&N. Obviously, those were, as we all know, fairly. Well, they were 5 cases that were heard together on appeal, and they changed the landscape considerably in respect of how the court views allegations, particularly in respect of coercive and controlling behaviour. So what's happened since then? Well, re B&B followed on from H&N. The reference is on the screen before you. And this is a case, it was one of the co-joined proceedings that the Court of Appeal heard following re H&N. And what's interesting about this is how the court viewed coercive controlling behaviour allegations in light of the previous decisions. And what the court found in this case was that the specific incidents alleged were not treated as freestanding events as they previously would have been, but as part of a wider pattern of abuse. The court was satisfied that there was a power imbalance in the relationship and that the father manipulated the mother, was abusive to her in a number of ways, was selfish, patronising and dismissive of her, and that his conduct caused the mother severe anxiety, depression and trauma. Her self-esteem was eroded and she came to believe that the relationship was normal. She simply sought, the court found, to cling to what she knew. So the court in this case clustered the allegations together, so in groups of physical abuse, psychological abuse, sexual abuse, and considered them holistically. And the judge in his judgment referred to that, where he said that the counsel in the case had asked that he consider the issues in a more holistic way, considering the patterns of behaviour of both parents during the length of their relationship, and that he had done so. And he said he was careful to consider the relevance to each specific incident to which his attention was brought. And the thing with coercive controlling behaviour, and it's been more recognised now, it's highlighted in H&M, is that it's nuanced. It's not easy to spot, and it's helpful if allegations are clustered. The issue with the clustering that I found with judges immediately post H&N, maybe even since B&B, is that there seemed to be a sudden view that schedules were no longer necessary and everything should be set out in a narrative statement. And whilst, of course, that is true for coercive controlling behaviour, that a narrative statement is required, it's incredibly difficult for the court to be able to focus on those patterns of behaviour if they're not set out in schedules. And so the schedules, in my view, in my experience, should be set out under the separate headings. So you might have 1 to 5 or 6 headings, as in B&B, clustered together under psychological, physical, emotional abuse, summarised very briefly so that the court can focus its mind on what is being said in respect of each type of allegation of abuse. Now, the difficulty that I found in respect of this approach is that instructing solicitors that have instructed me have prepared their schedules in a B&B compliant manner, and under each main heading, usually referred to as the overarching allegation. So in some terms, the overarching allegation is one, but it might have 5 or 6 components, which sets out the physical, the emotional, and the psychological abuse, and each of those may have 1 to 6 examples of such to be able to illustrate that pattern of behaviour. So the difficulty can be that there is not enough time allocated to hearings for fact-finding in coercive controlling behaviour, and I find that the court needs to be pressed to give sufficient time. I had a case recently where we had the overarching allegation was coercive controlling behaviour, 5 subheadings, but each subheading had 6 examples which needed to be taken together, needed to be litigated to show the pattern of behaviour. And the judge on this particular instance, whilst he did go on to determine all of the allegations and made findings in just about all of them, His comments in his judgment were quite critical of my instructing solicitor in that there were so many allegations. And he seemed to miss entirely that the landscape has changed and that in terms of coercive controlling behaviour, this clustering of allegations is the right approach. And whenever I have presented cases that have been drafted and pleaded in this way, I have found that the majority of the time it's much easier for the court to draw all the strands together and to make that determination that there has been coercive and controlling behaviour. And so I say that it's really important that we don't shy away from setting out in schedules, and briefly, it doesn't need to be war and peace in your schedule, but briefly highlighting what parts of each allegation you're relying on, because otherwise a lengthy statement for the court, and particularly in the process of a fact-finding hearing, isn't focused enough in my mind for the allegations to be properly determined. I'm going to move on now to another case, Re A. And again, this is looking at how allegations were viewed by the court. In this particular case, excuse me, there were 41 separate allegations. They were grouped together under 12 main headings, 7 different types, including stranding, physical abuse, threats of violence, sexual abuse, controlling and coercive behaviour, psychological and emotional abuse, financial abuse, and abuse of the child. And I would say that probably a lot of that would come under the overarching coercive and controlling behaviour in any event. The mother's case on the stranding allegation was that the father had removed her passport, her identity documents from her upon arrival in Pakistan, had coerced her into reporting them as being lost, which she did in September 2021, before stranding her in Pakistan. The father then said that the mother had lost her allegations. Now, this was a case where there were allegations on both sides. It was rather strange that the judge found that she took the father's view of what happened in England as being correct, and the mother's evidence, as in what happened in Pakistan, as being correct. And the judge found that the stranding allegation was the only allegation proved, and she rejected the evidence of the father on that issue. And rather surprisingly, having made that allegation, the evidence of the mother on all other issues. The mother appealed and sought a rehearing on 3 grounds. 1, that the judge had failed to consider the relevance of her findings of abandonment and stranding in respect of all the other allegations, that there was a flawed approach to the other evidence and insufficient reasons for those findings, that it was wrong to refuse to adjourn for an intermediary assessment, and that there was a failure to take account of the mother's vulnerability when assessing her evidence, although the issue in respect of adjourning for an intermediary assessment wasn't pursued at the appeal hearing. In considering that the appeal, the appeal court looked at the evidence and the judge's analysis of the same. And the mother in this case gave a very detailed account of a consistent course of seriously abusive behaviours in 2 countries, while the father denied everything. The possibilities were that the mother was broadly telling the truth, that the father was broadly telling the truth, or that each was telling the truth about some things and lying about others, there being no room for honest mistake. And the judge's conclusion was that the mother was lying about the events in England and the father was lying about the events in Pakistan. Their credibility, in fact, it would appear, running on geographical lines. On these facts, it was the view of Peter Jackson, Lord Justice, that that the judge in the first instance had reached a truly surprising conclusion. His view was that perpetration of domestic abuse was an expression of an aspect of a person's character within a relationship, and the fact that a person was capable of being seriously abusive in one way inevitably increased the likelihood of them having been abusive in other ways. There was no indication in the judge's first instance judgment that she had acknowledged this. Instead, and despite her very correct self-direction, she treated the various limbs of the mother's allegations as if they existed in unconnected compartments. And what this led the Court of Appeal to conclude was that the judgment reached, the conclusions reached by the judge could not be reasonably explained or justified, and that no other tribunal would have come to that conclusion. And the appeal was therefore allowed, and the matter was remitted for a full rehearing. But it's a very useful case, as it does provide a reminder of how different allegations are to be analysed in isolation and collectively, and it reiterates the importance of the broad canvas and considering all of the allegations in light of each other, particularly in coercive control. I'm going to move on to the next slide now. So in respect of that judgment as well, there was what I say a really poignant reminder for us of the observations of Judge Judd in Riem, that it's very important for a judge to give careful consideration to the question of vulnerability. As in this case, because a vulnerable person may not act in the same way as someone more independent or confident if they are exploited or abused in a relationship. And such an individual may be so anxious for the relationship to succeed that they accept treatment that others would not, and that they might be easy to exploit. And I raise that because it quite often, when we have fact-finding hearings, when there's allegations of domestic abuse, reference will be made to the fact that the alleged victim hasn't reported the incident either to the police, has continued with the relationship, and in some cases after separation has allowed contact to continue. And I've been involved in many cases, and indeed have often myself made the submission, well, you know, it can't have been so bad because mum or dad continued with contact being allowed after separation. So I say this case is a real reminder of how vulnerable witnesses can present entirely different to somebody who hasn't been the victim of domestic abuse. So going to move on now to the case of D and R, and this builds on the case of Re A in respect that it's a case that looks at the failure to properly consider Part 3A and Practice Direction 3AA, particularly in light of Section 63 of the Domestic Abuse Act that came in, that made the changes to Part 3A 2A on the 31st of January 2022. And the background to this case was that we had a father who'd applied for contact with the child. The mother made allegations of domestic abuse, including coercive controlling behaviour and a variety of sexually abusive acts, including in the presence of the child X. It was a remote fact-finding hearing. Both parties were represented and gave evidence via video, with both parties' cameras switched on throughout. And some of the questioning are clearly related to intimate matters, but at no stage did either of the legal representatives raise or the court consider, and I stress all the court consider, because there is not just a duty on advocates to raise issues of participation directions, but there's also a duty on the court to consider those, and neither considered the provisions of Part 3A. There was no reference to these provisions or real consideration of the mother's vulnerability in the written judgment that was given. And the judge partly relied in concluding that the mother's account lacked credibility on the way she gave her evidence and on inconsistencies in her evidence, and none of her allegations were found to be proven. So the mother appealed. She filed a statement in which she described not being able to concentrate during her evidence while she could see the father, and having found the situation very distressing, such that she was clouded with emotion. And it was argued on her behalf that the quality of her evidence could have been affected by the failure to put in place special measures. If you just move on to the next slide for me. So on appeal, Mrs. Justice Thies concluded, allowing the appeal, that in the cases of domestic abuse, the position is now very clear. A party or witness who is at risk of being a victim of domestic abuse is assumed to be a vulnerable witness or party. And where that applies, the court must consider whether it's necessary to make participation directions. And so I say that it's incumbent on us all to be live to that. The appeal was allowed on grounds 1 and 2 on the following basis: that the rules are clear and place a mandatory obligation on the court to consider vulnerability. So that's going back to, it's not just the solicitors and the advocates. No ground rules hearing took place. The court did not consider any participation directions, and the combination of the failure to consider Part 3A together with the lack of reference or consideration of the mother's vulnerability in the judgment had the consequence that the hearing was unfair and the conclusions could not remain. And therefore the judgment was set aside, and the matter was remitted to be heard by a different judge. I'm just going to ask Kane if he wouldn't mind going on there. And just finally, at the bottom of that slide, Mrs. Justice Thies was also clear that consideration of the requirements of Part 3A and Practice Direction 3AA should now be embedded in the legal landscape of these cases to ensure the important safeguards they are kept under active review. And since this, again, I'm pleased to say that within the new updated President's templates for Children Act matters, participation directions are included in respect of non-molestation orders, as well as Children Act orders as standard directions to be used. So that's a very positive outcome from that. And then the last case that I want to look at before I hand back over to Kane is in respect of coercive and controlling behaviour in financial remedy cases. Now, I'm not talking in any depth at all about financial remedy cases today, but this particular case is a really good example for practitioners. It's a Northern Ireland case, and the judgment was recently delivered on the 9th of April. And whilst it is a Northern Ireland case, and it was a very simplistic case and should have been straightforward, it wasn't a big money case at all, but it encompassed all of the aspects that can arise and are often pleaded in financial remedy cases. So it looked at needs-based cases, the principle of needs compensation and the sharing principle. It looked at conduct, consideration of coercive controlling behaviour, but also disclosure as well, and lack of disclosure. So it's a really good case for family practitioners because it gives a good romp through all the case law in respect of the court's approach to all of these issues. I flagged it today because of its reference to coercive and controlling behaviour in ancillary relief proceedings. So when looking at coercive controlling behaviour in ancillary relief proceedings, there isn't a lot of information out there for practitioners. And what this case highlights is that there is, however, a helpful report called Understanding Economic and Financial Abuse in Intimate Partner Relationships, which was published in 2020 by the University of New South Wales. And they identify that there is financial abuse, which is defined as one partner withholding money, controlling the money in the relationship, and failing to contribute to household expenses, and making one partner liable for joint debt. And also what is economic abuse, which it defines as not allowing or sabotaging a partner's employment, or not allowing or sabotaging study, and deliberately extending family court matters affecting property settlement. So we've already looked at some coercive controlling behaviour, and it's not a simple task for the court to conclude whether or not that's taken place. It's often covert domestic abuse. And what the Court of Appeal for England and Wales described in R&P, that's Children's Similar Fact Evidence, they described it as a subtle and persistent patterns of behaviour involved in coercive control, and described it as difficult to recognise by practitioners. And that's reinforced by H&M, which is relied upon as well. And what it identifies is that given that there's very little in the way of previous ancillary relief case law which has dealt with the issue of coercive control in ancillary relief, practitioners need to derive an understanding of this concept and the way it operates from the field of children's law and criminal law. And the fact that the financial impact of the behaviour may be unquantifiable does not mean that it should not be taken into account in financial relief proceedings. And there is a really interesting case, which I can never pronounce. Taveskos and Carryover is my best effort. It's a 2023 case where Justice Peel said that a party asserting conduct must prove that there is an identifiable, even if not always easily measurable, negative financial impact upon the parties which has been generated by the alleged wrongdoing, and a causative link between act and omission and financial loss is required. Sometimes the loss can be precisely quantified, and sometimes it may require a broader evaluation. A useful decision in terms of coercive controlling behaviour in financial remedy matters is Justice Motton, as he was then's decision in Haskell and Haskell. It's a 2020 case. And that provides a useful example of a number of aspects of coercive control. It was an application involving a husband born in the USA, but then residing in Moscow, who claimed his net worth at just under 90 million. His wife, born in Belarus, claimed by means of an Immerman document that the husband's net worth was $185 million. So although this was a needs case, clearly it's different from the needs-based cases that many of us will see. But what the judge found in this case was that there was a clear picture of insidious coercive control, in that the husband had put very clearly that the wife and children will only get money and be supported by the husband if they bend to his will. And Mostyn went on to say that the landscape got darker the more that the case went on. The decision in Haskell and Haskell was decided on the basis of needs. And although Mostyn did not explicitly mention that he had taken the husband's coercive control into account as conduct, which it would be inequitable to disregard, he did state, "It will be apparent from what I have written above that I have taken full account of all the matters mentioned in section 25 and section 25A of the Matrimonial Causes Act." And in light of that statement, it's difficult to imagine that, having found a clear picture of insidious coercive control, that Justice Mostyn had disregarded it. And therefore Haskell and Haskell may be the first recorded ancillary relief case in which coercive control was taken into account by the court as conduct. In the G&G case, the court found that there hadn't been coercive controlling behaviour by the husband, such that it needed to be reflected in the awards. And it reiterated that there must be a cause, an event, and a knock-on effect, if I put it that way, of the behaviour. So coercive controlling behaviour, the takeaway, is relevant insofar as it's impacted on a party's ability to engage in employment or to have advanced their career. But as I said before, it gives a really good summary of the law and principles in respects of need cases, the sharing principles, penalties for non-disclosure, and that's accidental omission as opposed to blatant hiding of assets, and litigation conducts, even in needs cases, and reiterates that even in needs cases where there has been litigation conduct, the award to the aggrieved party can be compensated. So that brings me to the end, hopefully just on time for the 1 o'clock break in terms of my part in the fact finding. Are there any questions arising from what you've heard in respect of that part? Nope, wonderful. So that should bring us to our 5-minute break.
Right, thank you, Suzanne. Like I said, we're just before we leave the topic of fact-finding hearings and schedules of allegations, there is one more case I'd like to talk about, which is, as you can see from the slide, is a case of re X and Y. I've included, as before, this case citation at the top of the slide. We have, up until this point, talked about fact-finding hearings within the context of private law proceedings, and also we've talked obviously about coercive behaviour in financial remedy proceedings. But there is obviously the dimension to fact-finding hearings in public law proceedings. And this case I've referred to on the slide, it is a first instance decision, although it does contain a lot of very useful summaries and pointers to the relevant law in respect of fact-finding hearings in public law proceedings. And just to talk about the background, factually, this case was interesting in that regard. It involved a child named Zed, and Zed, of course, had his parents, but Zed also had an older sister who was involved in these proceedings as an intervener. And the reason why she was involved as an intervener is Zed's older sister herself had 2 children. Unfortunately, regrettably, they both had died. One of her children had died some time ago, but more recently, a second child who was relevant to these proceedings, who was labelled C, had died at the age of 6 months. So Zed, his older sister, his mother, and his older sister's children had all lived together as a family unit at different points. Now, the local authority in this case were naturally concerned, most pressingly, about the reasons why C had died at such a young age. But they also had real concerns about chronic neglect of Zed by his mother. And in respect of C, there had been a post-mortem report commissioned to essentially investigate the circumstances surrounding that death, and of course determine perhaps whether it was a non-accidental injuries that led to death, and whether and then the court would then potentially go on to consider that post-mortem report when looking at whether it could identify a possible perpetrator or indeed a pool of perpetrators as part of a fact-finding hearing. Now, in terms of the parties' positions in Re X and Y, the local authority had been pushing for a fact-finding hearing on the issue of potentially identifying the exact cause of the death of C. However, they wanted to adjourn any potential fact-finding until that post-mortem report had been received. They did, to summarise it, they didn't want to proceed without that information available, which, as you could all probably guess, would be fairly, very strong piece of evidence, depending on its outcome. Of course, if the report had indicated it was a non-accidental death, then that would be obviously a key piece of evidence to the local authority. The mother's position in the proceedings was that she didn't dispute the need for a fact-finding hearing, but she didn't want to adjourn it. Essentially, she wanted to proceed immediately to a fact-finding hearing, notwithstanding the fact that this post-mortem report hadn't been received. Now, the children's guardian's perspective was more interesting and nuanced, and I'll talk about it in more detail when I talk about the actual outcome in this case. But they not only did the children, well, if I can summarize it like this, the children's guardian didn't feel that there was a necessity at all for a fact-finding hearing, and matters could progress straight to the welfare stage. So that's the factual background and the respective parties' positions. If I turn to the next slide, in terms of the test, which some of you will be aware already, but in terms of the test that the court needs to apply when it determines in public law proceedings about whether a fact-finding hearing is necessary, I've put the full case name at the top of the slide, but it's commonly referred to as re-DP, and that was a 2005 decision from the High Court. And the High Court in that decision provides a list of factors, essentially, that the tribunal would need to look at in order to determine whether a fact-finding hearing was necessary. Now, I'll read them out. Of course, a lot of them are fairly self-explanatory. There's the interests of the child involved, those being relevant but not paramount. There's the time that the investigation would take, cost to public funds, because, of course, in public child law proceedings, it's often at the expense of the public purse that experts and professionals and advocates are instructed. So that's often a live issue the court needs to deal with, particularly if a fact-finding hearing is going to take some time, if it's an extended one, perhaps for 5 or 10 days at the longest. And there's the evidential results, the necessity or otherwise of the investigation, impact of the fact-finding process on other parties, that extends just not only beyond the emotional impact of the parties, the prospects of a fair trial on the issue, and the justice of the case. Now, what I'll do is I'll talk about the actual decision and the outcome in this case with reference to these factors. But just before I do so, just to expand a little bit on that last factor, which is the justice of the case, which is perhaps fairly a bit vague, if I can put it like that. When you read into the decision of this case, re X and Y, essentially the judge expresses himself as saying that the justice of the case refers to really a consideration of the overriding objective, and the need to look at every case in the round. And the judge, when looking at the overriding objective, pointed to, as you know, we're all aware, specific sections of the overriding objective, namely the need to deal with matters expeditiously and fairly, but also to allot essentially cases an adequate and appropriate share of the court's resources, bearing in mind the need of those resources in other cases. So that's just a little bit of an expansion of what's meant on the justice of the case. But if we actually look at the decision in the case itself, I'll just turn to the next slide. It was an interesting decision because the issue of the post-mortem report was, at least from the court's perspective, a bit of red herring, in the sense that court's first decision on the issue about whether any fact-finding hearing should be adjourned until this report had been received was that it shouldn't. And the reason for that, again, as probably some of you can anticipate, is that we're all subject to the statutory 26-week deadline in public law proceedings, and waiting to hold a fact-finding hearing until this report had been received really risked essentially huge slippage in the timetable for proceedings, which ultimately is inimical to Zed's welfare. So, amongst other reasons, it was really cited that delay was the key reason why any essentially an adjournment to get the post-mortem report wasn't justified. But I said earlier it was a red herring because, as you'll see from the slide, the court's eventual decision in Re X and Y was actually that a fact-finding hearing wasn't necessary at all, and that matters could proceed straight to the welfare stage. And the court arrived at that decision after applying the re-DP test that I set out earlier. Now, there were, and I would invite everyone to have a read of the judgment, because it is a really useful summary of the specific factors that I've listed out earlier that the court needs to look at. But really, the key reason why the court concluded that a fact-finding hearing wasn't necessary is because essentially the threshold that had been pleaded by the local authority was one of chronic neglect of Z. And the court concluded that there was really an ample amount of evidence available to the local authority to enable it to essentially meet the threshold without having to go through the trouble of essentially establishing or the fact that C had potentially been had died through a non-accidental injury. And to that extent, essentially any fact-finding hearing to determine that matter was surplus to requirements. Now, I mentioned the Guardian's position earlier because that was the position taken by the Guardian. Not only did they not support an adjournment for the post-mortem report, but they essentially echoed the court's reasoning, which is that, if I can summarize it like this, we have enough evidence to meet the threshold, so further delay for a fact-finding hearing isn't needed. But if I talk about some of the, or expand upon some of the specific factors that I mentioned earlier, I'll turn back to the previous slide. As I said earlier, a lot of these factors are fairly self-explanatory, but just to talk in more detail about some of them. The first one, which is the relevance of Z's interests. One of the key reasons why the local authority sought a fact-finding hearing, and one of how they resisted essentially this argument that it wasn't necessary because there was already a lot of evidence available, was that they felt that a fact-finding hearing being undertaken and potentially a finding being made as to how C, the child, had died, would be very important to Z's life story work and the effectiveness of any future therapeutic intervention. Now, the judge was sympathetic to that point, but I think really the Achilles heel of the local authority's argument is that one of the experts instructed in that case, who had presented a report about possible therapeutic interventions, had essentially set out options that could be effective, even if there hadn't been a specific finding made about how C had died. So the judge placed a lot of weight on that, and like I said, although the judge was sympathetic to the point, it still didn't really support why a fact-finding hearing was needed. The other point that the judge set out in relation to this factor was that, of course, there wouldn't be a fact-finding hearing in the family court proceedings, but of course, if this post-mortem report was received later down the line, and then it pointed strongly to essentially C's death being non-accidental, then that would open the door to a criminal prosecution being continued with and a criminal trial being undertaken. And what the court, or more specifically the judge, said is that the outcome of any criminal trial, as well as indeed actually the contents of a post-mortem report, could be explained to Z later down the line if this was thought necessary for his life story work. So it wasn't justified to essentially delay for an inordinate amount of time the family court proceedings when it might otherwise be resolved in the criminal courts if that post-mortem report led to it, essentially. Now, looking at another factor on the list, it's the relevance of any result to future care plans. Now, when you read the judgment carefully, the judge actually says that this was probably the strongest argument in favour of a fact-finding hearing being conducted. And the reason for this, and this was a concern expressed by the social workers in the case, is that, of course, the local authority, as part of any care plan, has to consider how future contact is going to happen and what that's going to look like. And social workers had expressed that a lack of a clear factual matrix as to how C had died would present real difficulties in essentially effectively planning and safeguarding any future contact. And the judge, as I said earlier, did see force in that argument. But what the judge pointed out, and this is perhaps a bit controversial from a kind of risk assessment point of view, but the judge did say that Z is an older child now. If I'm not mistaken, he was about 11 or 13, I think, at the time of this judgment, whereas, of course, C had died at the age of 6 months. So what the judge pointed to is that, looks, as a 6-month-old child, you're not going to be able to report or express mistreatment to professionals. Whereas obviously an older child at the age of 11 or 13, it would have the capacity to do that. So the judge drew a distinguishing factor there. But the other point that the judge relied on in response to this factor is that there was no actual specific suggestion put forward by the local authority that Z had been mistreated to the extent that there had been a serious threat to his life. And the threshold was one of chronic neglect as opposed to any serious, as I said, risk of physical injury or even death. So if I can put it like this, there wasn't that crossover between the possible background to C's death and what had been pleaded by the local authority, which was chronic neglect of Z. So for those reasons, the court not only, as I said, kind of put aside the red herring issue of the post-mortem report, but overall declined to actually direct that fact-finding hearing was necessary at all. So really, I mean, it's I suppose I can frame it as a key takeaway, but really the judge in this case was clear to express that the law is settled in this area and that any decision to proceed with a fact-finding hearing in public law proceedings needs to consider those re-DP factors very carefully, and a kind of broad overview of the case needs to be taken, and a judgment call needs to be made about whether it's actually necessary to go through that process, particularly when, as the judge concluded, threshold might be met otherwise on other evidence. But that concludes the fact-finding hearing section of this presentation, and I'll pass you back to Suzanne.
Thank you, Kane. Just before I move off of fact-finding, I've just noted that I omitted one slide, so it will be contained in the handout, but it's just the reminding us all, as we referred to applications to reopen fact-finding hearings, what the test for that is, and that's set out in Re-E. It's a judgment of Peter Jackson from 2019 case, where he says that the court faced with an application to reopen a previous finding of fact should approach the matter in the following way. And there's three limbs to what is said. That the court should remind itself at the outset that the context for its decision is a balancing of important considerations of public policy, favouring finality of litigation on the one hand and soundly based welfare decisions on the other. Secondly, it should weigh up all relevant matters, which include the need to put scarce resources to good use, the effect of the delay on the child, the importance of establishing the truth, and the nature and significance of the findings themselves. And thirdly, above all, the court is bound to want to consider whether there is any reason to think that a rehearing of the issue will result in a different conclusion from an earlier trial, and that ultimately there must be solid grounds for believing that there should be a revisiting of the previous decision. So it is that will be included in the slides, but just for completeness sake, I raise that before we move on. So I'd be very grateful if, and there we are as if by magic, the slides in respect of parental alienation. So what is parental alienation? Is there even a definition? And the short answer to that is no, there isn't. There's a lack of consensus as to what its precise definition is, and that often results in misunderstanding and misuse. There is a helpful guidance from CAFCAS, which is set out as when a child's resistance or hostility towards one parent is not justified and it's the result of psychological manipulation by the other parent. It's one of a number of reasons why a child may reject or resist spending time with one parent post-separation, and alienating behaviours present themselves on a spectrum which varying impact on individual children, which require a nuanced and holistic assessment. And therefore it's helpful to bear in mind that where allegations of parental alienation are made, it's necessary for the court to make a specific finding, and expert assessment is likely to be required in order to establish the reason for the breakdown in contact. And that feeds nicely into our previous slides in respect of experts in the family court, and in particular in respect of parental alienation. It's not uncommon, all of us as practitioners will have seen that whenever there are applications to the court, particularly if one parent, usually the parent with whom the child lives, will say that the child doesn't want contact with the other parent and lists a number of reasons, then the I'm going to use the old term, non-resident parent, but the parent with whom the child doesn't live, will often come back, and we see it quite often on the C1As and in statements that they're being alienated from their child. So in terms of parental alienation, there are often applications to join a child to the proceedings, and I just want to, because of that, just touch very briefly on the joinder of children. It's readily acknowledged that making a child party to a proceedings and to appoint a guardian under the rule 16.4 is, well, it causes delay for a start, but there are certain criteria which need to be, or recommended is in place for that appointment. And usually the one that is most relevant is where there's an intractable dispute over residence or contact, including where all contact has ceased, or where there's an irrational or implacable hostility to contact. And that's the limb that most of the applications that are made comes under. We're all aware of the delay that the appointment of a 16.4 guardian can cause. At the moment, in my experience, the delay can be sort of 3 months or more, initially while CAFCAS are able or unable in some cases to appoint a worker, and then waiting for court time whilst there has been the hearings necessary to get that underway. However, having said that, there is an increased appreciation of the seriousness of a child being denied a relationship with one parent now in private law proceedings, and therefore it reminds us of a pressing need to identify early and address potentially intractable cases at the earliest opportunity. So as soon as we can, really. Quite often we'll get past DRA before somebody determines to make an application for 16.4 guardian. So the takeaway for me from this is to consider it at the earliest opportunity, particularly where there's been no contact at all, save in cases where we have fact findings underway, and so that it can be addressed at the earliest opportunity. It's again recognised that each case turns on its own facts, and the court doesn't always accede to the application for Rule 16.4 guardian, and it's refused multiple applications in a particular case we're going to look at in a moment, re A and B, because it was determined that it would not be in the child's best welfare interest, which of course is the test for a Rule 16.4 guardian. So in terms of parental alienation, who decides whether or not there has been parental alienation? And at the case that we looked at in depth previously, Re-C, in terms of that question, what was said there is that it's a question for the court. It's not a diagnosis, and it should not be offered by a psychologist. And for those purposes, the ACP UK wishes to emphasise that parental alienation is not a syndrome capable of being diagnosed, but a process of manipulation of children perpetrated by one parent against the other through what is termed as alienating behaviours. But fundamentally, the court has found that it's a question of fact. he goes on to say that most family judges have for some time regarded the label parental alienation and the suggestion that there may be a diagnosable syndrome of that name as being unhelpful. And what is important, as with domestic abuse, is that particular behaviour is found to have taken place within the individual family before the court, and of course the impact that that behaviour may have had on the child or his relationship with one or both of the parents. And therefore, in that regard, the term alienating behaviour should be the focus of the court's interrogations, rather than any quest to determine whether the label parental alienation can be applied. When there is parental alienation, and in particular when it is missed, it can have dire consequences for the children and for the family. Re-C was followed in May 2023 by Re-A and B. Now, this case was a long-running case, and as the slide shows, that there were multiple judgments in this case. So in March 2019, November 2020, February 21, March 21, July 21, and so on. And the background to this case, excuse me, is that previously the parents had a shared care arrangement which had worked well for a while, and then over time the children had begun making allegations against the father. The shared care broke down, and the matter was in proceedings for 4 years, and it was described, the history of the family was described by the presiding judge as being torturous. In the midst of these proceedings, the court had a fact-finding hearing. Serious findings of fact against the mother were made, and the children were moved to live with the father. I'm going to jump to 2021, so some way through those protracted family proceedings where there were multiple appeals by the mother, and I'll come on to some of those towards the end of those proceedings. But in December 2021, the court held a hearing, was invited to and acceded to an application on behalf of the father to have a without notice hearing to the mother. And at that hearing, the judge was told that the previous day, at a session held by Miss Woodall, who was a specialist at the family separation clinic, so working with families where alienating behaviours seemed to have taken place, she was called to give evidence. And what she told the court was that the children had explained to her that since they'd been in the care of the father with some limited contact to the mother, they had been approached many times since that decision in of the spring of 2020-21 and put in contact with the mother in breach of the court order. The children made reference to being approached by a, to use their words, strange man on their way to school, or rather worryingly, during sporting activities, either at school or outside of school. They were given tracker devices by the unknown male. They were given mobile phones to contact the mother, and occasionally, and more occasionally, the maternal grandparents. And they were given cash to buy mobile phones to have contact with their mother and maternal grandparents. And during these conversations, with the mother and the maternal family, the children were told, amongst other things, to run away from the father's home, told to make false allegations of abuse against the father, and as time progressed, to make more serious allegations. And the allegations did become a lot more serious. There were occasions when the children had run away from the father, once in this jurisdiction and once whilst in America, and then had latterly been returned to the father's care. But it was a case where the mother consistently fed into the children these negative comments about the father, but more than that, she encouraged what she knew to be false allegations against the father. And if I could just ask Kane to move on for me to the next one. So that just gives a little summary of how the children ended up living with the father. This was a case where the mother made multiple applications, as alluded to slightly earlier, for the children to be joined as parties. And these were again refused on the basis that they were not in the child's best welfare interests. In particular, the judge found that having made significant progress in their presentation, in their attendance at school, their ability to concentrate at school and how well they were doing, and their relationship with their father, to join them as a party to proceedings, and for them to have to, in effect, due to their joinder and Kafkas's involvement, have to relive those issues which the court had already found had caused them significant harm, was considered not to be in their best interests. Well, things rattled on with their mother in respect of the allegations that she made. At the hearing on the 15th of December, the judge made certain directions. One was that it wouldn't be appropriate that the children attend their schools, rather unusually, until a further hearing on the 12th of January to prevent them being approached by the unknown male. That Miss Woodall was to prepare a report setting out the allegations and disclosures, although we don't call them disclosures anymore, the statements I'm going to call them, made by the children on the 14th of December. And that thirdly, there should be a transcript of the evidence that Miss Woodall had given to the court at the without notice hearing and made available to the mother, or not made available to the mother or her legal team until the start of the hearing on the 12th of January, when they would be given time to consider the same. Due to listing, as I understand it, the hearing on the 12th of January was adjourned to the 19th. Now, the mother had made various applications to adjourn hearings, not to attend hearings, not to attend in person, to attend remotely. They'd all been refused, and the mother was directed that she was to attend in person on the 19th of January. However, she didn't attend. This case is quite notable because of all the applications, not just by the mother, but they also involve the Metropolitan Police. And on the 31st of January, the court granted an application by the Metropolitan Police for the disclosure to them of transcripts of various court hearings from the 18th of October 2021 onwards, which is quite unusual at that stage, given there wasn't an indication at that time that there was a criminal investigation. On the 24th of March, the court refused an application by the police to discharge the orders preventing the police from interviewing the children. So it would seem at that point onwards there may have been consideration for police involvement. And then on the 15th of May, the police were given permission to appeal the order of the 24th of March, which was refusing the police to be able to discharge the orders preventing them from interviewing the children. And then on the 15th of July, the Court of Appeal allowed the Metropolitan Police appeal against the order of the 15th of October. So they were actually able then to interview the children. Well, following that, the mother then made an application for the judge to recuse himself from the case. On the 5th of October, the judge refused the application. The mother appealed. Again, this was refused by the Court of Appeal on the 9th of December. On the 8th of February, there was a pre-trial hearing relisted, a fact-finding hearing was scheduled, and the mother was ordered to attend in person. Thereafter, the mother made another application on the 17th of April to exclude the evidence of Miss Woodall. This was refused on the 4th of May, and then the mother made another application to appeal that order of the 4th of May. So in all, I think on my last count, there were some 11 appeals by the mother in respect of case management decisions, fact-finding hearings, and other orders made. In light of the pending fact-finding hearing that had been listed, Lord Justice Peter Jackson considered the mother's application on the 15th of May and refused her permission to appeal. Once that order was served upon the mother, she had no further communication with the court or with the father's legal team. She didn't attend the fact-finding hearing in person or remotely, and no explanation was ever received as to why. And you'll see from the bottom of the slide that the findings made against the mother were significant. And in concluding judgment in respect of this, what Mr. Justice Keenan said was that there was a long history where the mother pursued her own agenda without any regard whatsoever to the well-being and welfare best interests of the children. She orchestrated a campaign against them, tracking the children, making covert communication with them, telling the children to run away from dad, and that she'd seriously abused child A and B emotionally and psychologically. And this is one of the few cases, I say, where the mother has no future. Well, the court determined that the mother, in the children's best interest, should have no future of any description in the lives of her children, and that's quite a draconian view for the court to have come to. But it's clear that in cases where alienating behaviours aren't identified and aren't dealt with swiftly, the impact for the family and the children can be dire. Following on from this case, I was involved in a case which concluded in December. The judge has given permission for it to be published. I'm just waiting for the approved judgment to be published. It will be referred to as REW. And although it's not on the slides, I just want to flag that particular case because it draws perhaps the strands of our presentation together, in that it is a case where when a professional has got something wrong, it has led to what was described by the expert in the case as one of the worst cases of parental alienation. So this particular case started off in private law. It concerned a boy who was 15 in December at the time of the final hearing. He had lived with his mother since the parties separated at the age of 2, and has spent time with his father, so weekends and holidays, but there'd never been a shared care arrangement until quite a few years later, where the parties did share care for a period of time, but very quickly after that the child started not wanting to have contact. Well, he was living with his mother, he wouldn't speak to her, he wouldn't engage in communication with her, and he wouldn't talk to her at all. And there were some rather disturbing recordings, and although the court doesn't condone recordings of children, these particular recordings were quite eye-opening. The mother had recorded them in desperation, and they were conversations between her and the child, which were frankly quite shocking to listen to, the level of abuse from, at that time, a 14-year-old boy towards his mother. Interestingly, in terms of recordings, the father had also produced recordings for the court of the child when he was 18 months to 2 years old. He produced that at the final hearings. It hadn't been produced all through the lengthy private law proceedings, which turned into public law proceedings. And he produced that as an indication of how the mother had abused the child. And in that recording, the child is seen playing with his toys. He's got a bruise on his forehead, and the father is repeatedly saying to him, you know, mummy did that. Is that how, you know, from mummy hitting you? Until eventually the child had said yes, but showing no interest in the father's conversation. So, as I said, this started off as private law proceedings when the father then wanted the child to live with him. There was a fact-finding hearing in the private law proceedings. Allegations raised by the father that the mother had caused emotional harm to the child by being controlling and coercive and attempting to exclude the father. That wasn't found. That the mother had caused emotional harm to the child by reacting to him to punish him for expressing a wish to spend more time with that with the father. It was proved to some extent, although the court found that the father bore considerable responsibility for that because of the abuse that the mother suffered at the father's hand, and that in effect the father was using the child to effectively bully the mother by proxy. And then the court found that the mother and the child had both suffered abuse and harm as a result of the father's coercive and controlling behaviour. He sought to consistently undermine the mother's relationship and her parental responsibility. And in seeking to alienate the child from his mother, he presented him as a primary source of support and deprived the child of therapeutic support. And one of the key issues and concerns was how the child mirrored what the father would say. And there was this feeding of, the father called it love and affection, but it was for me quite a chilling scenario where the father's kissing the child on the lips, he's holding, he's hugging, I'm the only one who loves and looks after you, and you won't survive without me, which the child came to adopt. So such were the court's concerns, having held the fact-finding hearing, that it ordered a Section 37 report from the local authority. Notwithstanding the real serious concerns, and I've summarised it down to a real nutshell, so rather surprisingly, the local authority concluded that, yep, things look pretty bad, but not so much so that they needed to intervene. Matters proceeded through the courts, but things got worse for the child at home, and he was self-harming. Needless to say, the court ordered a further Section 37 report and asked the local authority to please look again at the issues. And again, on a second Section 37 report, the local authority declined to issue any proceedings. Therefore, a guardian was appointed, Rule 16.4 guardian at that point, and an expert was instructed to undertake a psychological expert report. That expert said that the child's relationship with the mother had been undermined and his attachment to her eroded. He wasn't aware of his father's emotionally abusive behaviour, and he saw his mother as the one being abusive. And he said the consequences for the child were very serious, saying, I stress to the court that this is a very, very serious case of parental alienation because of the child's strong irrational beliefs, the father's serious lack of insight and failure to address when the child talks about the mother, and the mother not being able to have any significant relationship with the mother. And he went on to say that the child had a damaged self of reality and reality testing, and his view as a mother was so far from the truth that he was developing a system of thinking characterized by persecution, leading to paranoia and potentially psychosis or a psychotic predisposition to his personality. So it's only at this point, on receipt of this report and a third request to the local authority, that the local authority thereafter, rather late in the day, issued some care proceedings. And as part of those care proceedings, looking at where the child could be placed. The child was initially placed in a family placement with a maternal aunt, but due to the father's consistent, persistent and continual undermining of the relationship, that broke down, and the child ended up in a foster care therapeutic placement where unfortunately a year later he still is. He has no relationship with his mother. That relationship was so damaged that by the time the intervention started, and although the recommendations were made for the father's contact to cease and for the local authority to focus on rebuilding that relationship between the mother and the child to the exclusion of the father, the local authority didn't exercise, in the expert's view, their parental, and it's quite unusual for an expert to pin their colours to the mast so finely, to say that the local authority's failure to exert their parental responsibility had led to a situation where it was unlikely now that this child was ever going to have a relationship with the mother, and the local authority to some extent and purposes gave up trying to rebuild that relationship and started contact with the father again. And so the final hearing, the mother accepted that she's not going to have her child back living with her, but was focused on the local authority, who at the end of the hearing wanted to have no further involvement. But luckily they did relent on listening to the evidence and the submissions made that there should be further intervention. And I raise this case because as practitioners, when we see the alienating behaviours that are told to us by our clients, when we see the impact on our cases, this is a case that cried out at the earliest opportunity for an expert report, and it was only after consistent failures by the local authority that one was commissioned, that the local authority thereafter interacted. But of all the experts in this case, it was concluded to be one of the most serious cases of parental alienation that had been seen. And had the local authority, bearing in mind the first Section 37 report was some 2 years before the final hearing, had they recognised, had they started proceedings, had they taken some action at that stage, the outcome for this child might have been very, very different. And so it's for that purpose that I raise that as a notable case, although I can't give you the reference for it because it's not actually published yet, but we're expecting that to be published any day. And so that brings me to the end of our presentation here. There are just a couple of things again that aren't on the slide, and I will give time for some questions if there are any after. It's just some notable things that are happening, hopefully this year. So in January 2024, the Ministry of Justice proposed amendments to the Victims and Prisoners Bill, and this now moves up to the next stage. And the proposal was announced in 2022, seeking to automatically remove parental responsibility for parents convicted of the murder or voluntary manslaughter of their co-parent. It emerged after the death of Jade Ward, whose partner had and father of her child murdered her in 2021. And so the Victim and Prisoners Bill is a long-awaited piece of legislation aiming to strengthen the rights of victims of crime, and the result of that is eagerly awaited. Also, there is a further look at prenuptial agreements becoming binding in this country. At the moment, they're persuasive but not binding. But the Law Commission is producing a scoping paper with a targeted deadline of September 2024, which will include consideration of whether there's need for further work on nuptial agreements. Given the glacial pace of reform, there's unlikely to be anything substantial this year, but it's something to look forward to. And hopefully we should get the result of the transparency pilot in the family courts. That was launched on the 30th of January last year, introduced in Leeds, Cardiff and Carlisle. It was to run for a year, and it allowed accredited journalists, reporters and legal bloggers to report on what they see and hear in court, and allowing them certain access to documentation and skeleton arguments and some position statements. We haven't got the result of that yet. However, if it's able to increase the public confidence in the family court whilst ensuring that parties involved remain protected, it could bring out a positive change. And finally, perhaps the most relevant one is that the government is reviewing the 50-year-old legislation that determines how financial assets are split after divorce, and there is going to be a law review to carry out a detailed analysis of the current laws that were put in place 50 years, half a century to go. There'll be various considerations, but a key focus will be on fairness versus certainty. And it's expected that the Law Commission will report their findings in September 2024, and it could include future financial remedies forms. So it's at the first stage of a long process, and there may be some reforms implemented depending on the findings of the report. But just a few things to look forward to in 2024. So that does bring me to the end, unless there are any questions for either Kane or myself. Thank you. On that basis then, Eloise, I'm going to hand it back to you.
Thanks so much, Suzanne. That was incredibly helpful, very thorough. We will be sending out, and to you too, Kane, we will be sending out the slides and a recording to everyone that's attended and everyone that registered but hasn't managed to join us today. Hopefully that's covered everything. We will also be sending out the assessment summary. So if anyone who's attended today could complete that, that's so helpful in terms of generating feedback and preparing our programme for next year. So I think that's everything. Thank you again to both of you and to Guildford Chambers for your continued support of Surrey Law Society.